welcome. Very excited today that we're going to do part 3 of our 10-part series webinar program. This one entitled D&O Coverage Considerations in the Wake of COVID-19. I've got 3 great panelists here. We've got our managing partner and 2 senior lawyers of our Northeast office. Let's start right in and let them introduce themselves. Theresa Guertin, let's start with you, our managing partner.
Hi, I'm Tracy Guertin. I'm the managing partner of SDV Northeast. I've been with the firm since 2008, and I lead the Directors and Officers Practice Group, which is our fastest growing practice group nationally. And you'll hear a little bit from my colleagues, Grace and Alex. The 3 of us have been doing a lot of D&O work over the past few years, and we're excited to talk to you today about D&O in the context of COVID-19. Alex?
Thanks, Theresa. Hello, everyone. I'm happy to be with you here today. My name is Alex O'Neill, and as Theresa indicated, I'm also part of our D&O practice group. I've been with SDV for about 7 years now, and within the D&O practice, I'm particularly interested in helping guide policyholders through government investigations. So that's something I've really enjoyed. Grace?
Hi, everyone. Thanks, Alex. My name is Grace Hebbel. I'm also a part of SDV's D&O practice group. Within the practice group, I've had the opportunity to represent clients ranging from a hedge fund to a celebrity, and each client presents a new and unique challenge, which is really exciting.
Well, so let's jump right into the program. I'd just like to, for the audience that's out there, everybody may not be as familiar, and some people might be very familiar with D&O coverage. But we should understand that D&O coverage is a liability coverage generally, although I think we'll speak a couple of exceptions where there might be some first-party coverage. But we're talking about generally covering other people's losses for claims against you that might involve the D&O coverage. And essentially, we're going to start out with some overview, and then we're going to talk about how COVID-19 might have an impact or how your coverage might apply under the D&O circumstances for COVID-19. So let's start off with Theresa, if you can just generally give us an overview of how D&O coverage works.
Yes, thanks, Tracy. So D&O coverage, as you mentioned, is a type of liability insurance. So it applies when there's a claim made against the insurance. Interestingly, as opposed to what many people are familiar with, general liability, there doesn't have to be a suit per se, but a claim or a demand. So it's a lot broader in some respects than other types of liability coverage, and can apply when you're being investigated by the government, or if you've gotten a demand from an injured claimant, concerning something that's covered by the policy. So just from a broad, big picture perspective, what we have is usually there's 3 parts to a D&O policy. And they call them the side A, side B, and side C. That's kind of the D&O lingo. So side A coverage is coverage for the directors and officers of the company when they're not indemnified by the company. Sort of sitting behind all of this, think about the way companies are structured. There's this board of directors and officers, and usually there's some sort of operating agreement where the company is agreeing to indemnify the directors and officers for various liabilities. Well, for some reasons, there might be some liabilities that directors and officers face that they cannot be indemnified for. So this side A coverage provides protection for those directors and officers when that's the case. Side B coverage is sort of the opposite of that, or the reverse of that, where the company does indemnify the directors and officers, and it gets reimbursement from this side B coverage. And lastly, we've got side C coverage, which is the coverage for the entity itself. When the entity is sued alongside those directors and officers, they can get the protection that they need, defense and indemnity, from this policy from side C. Couple other important things, D&O can be a package policy bundled with several other types of coverage. I think importantly for our discussion today is employment practices liability insurance. We'll talk a little bit about that later. but that's usually bundled together with your D&O coverage, along with a few other types of coverages. So let me just... So I think the last thing I was going to mention is just that coverage is claims made. So again, a lot of people are used to general liability where coverage applies when the occurrence takes place. The major difference with D&O coverage is that you have to report your claim to the policy that's in effect at the time the claim is made against you. And there can be some serious consequences if you fail to do so within your policy period. So that's, I think, a good overview of what D&O means, Tracy. Maybe one of my colleagues can expand on that a little.
All right, so Alex, do you want to kind of jump in here and maybe talk a little bit about other parts of the D&O policy?
Sure. So as Theresa indicated, your typical D&O policy has those three different sides, but based upon the policy specific to that policyholder, you might have other coverage extensions that are available. Typically, these are going to be subject to lower sublimits of liability, so you won't have, your full limit of liability. And they can even provide first-party coverage, such as public relations expenses if you're dealing with a bankruptcy and you're getting negative press, or perhaps if a director or officer is indicted. You might have some expenses covered under your D&O policy. And this is just a really important reminder for folks now to read through your policy and know what other coverage extensions you might have. They're going to be things that you might not expect under a D&O policy and might be very specific to your insurance carrier. So review your policy now, know what you have available, and also remind yourself of the specific notice provisions for these coverage extensions. They're sometimes going to be different than the notice provisions in your base policy form. So you want to know when you have to give notice so that you don't compromise this potentially important coverage.
Grace, can you comment further about either the notice provisions or general coverage issues before we dig in on the COVID-19 issues?
Yeah, absolutely, Tracy. So as Theresa mentioned earlier, D&O policies are claims made, making the notice portion of this even more important. D&O policies allow the policyholder typically to give notice of either a claim that's been made against them or a notice of circumstances that may later give rise to a claim. The benefit of giving a notice of circumstances is that any claim that results from such circumstance will then be deemed to be made during that policy period under which notice was given. And for that reason, we do encourage giving notice early and often, with one important caveat, and that's heavily dependent on the specific policy language. D&O policies almost always have what we term prior notice exclusions. Depending on how that reads, that would exclude coverage for claims that arise out of facts or circumstances that were the subject of notice in a prior policy period. So policyholders should make sure that any prior notice exclusion in their policy states that notice must be given and accepted in the prior policy period in order for it to apply.
So would anybody like to comment further about some of these notice issues or things related to that?
Yeah, Grace, I think what Grace said is so important because you really need to know how your policy is going to operate with the notice and the exclusions. And that might not be something people initially think about, how an exclusion could preclude coverage if you give notice. And so knowing your policy, speaking to your broker, speaking to coverage counsel is really important before you just sort of give a blanket notice of circumstances for COVID-19. I think a lot of companies right now haven't had a claim against them. So they're really looking to say, okay, should I give notice of circumstances if my policy period's ending soon and my reporting, procedures are coming due? So I think it's really important to think critically about whether or not you're going to give a notice of circumstances, what that notice should contain, and how it might impact coverage moving forward.
Yeah, I just want to jump in and add too that it's forward looking. So if you have circumstances in this policy period, you want to be thinking about your renewal and what language is in that renewal, because that could be detrimental to what you're doing in this policy period.
I was also just going to add that, I think that's great advice from the both of you about notice provisions. But, some of the most interesting and challenging cases that we've handled together involve just this very thing where an insurance company is claiming that the insured should have reported earlier than they really felt they needed to, because they knew sort of vaguely that a claim could have been made. Now, we always argue that those are not legitimate arguments that the insurance company is making, that really until a claim is made, there's no duty to report. But it's important in this, I think, scenario to think about that early notice of circumstance, perhaps, because this is bound to be something that's going to be litigated and dealt with by the carriers for years. So best to get your notices in early if you really think there's going to be a potential claim.
I just want to maybe throw the question out there then. I know at some point we'll probably talk about the renewal process, but during renewal, there's an application that comes in, and will that have some impact on these notice issues? There's some way in which you could see that being implicated here? Theresa, do you want to comment on that?
Yeah, absolutely. Typically there's this application process, which you referred to every year, and you're obligated to alert the company to any, alert the insurance company, that is, to any potential liabilities or claims that you might know of. And if you're not careful and you don't report those things, you can face what's called a rescission action, where after the fact, the carrier attempts to say that coverage should not apply because essentially you lied or you materially misrepresented the liabilities of the company. And I think, Grace, you've seen some specific questionnaires about COVID-19 in connection with the application process. Is that right?
Yeah, there has been a lot of press about underwriters creating specific COVID-19 questionnaires, and when companies are faced with these, it's important that a cohesive narrative comes across, and that, honest but carefully crafted.
Let's dig in a little bit further. And first of all, I'm going to ask this question related to private companies, because when it comes to D&O, sometimes you'll see different types of claims that arise with publicly traded companies and private companies. But Alex, if you don't mind starting off with this, what are some of the risks that private companies are facing in light of COVID-19?
Sure. So one that really, hits us off the bat is government investigation. So obviously Congress has been providing significant funding to companies, private companies. And with that, you have potential liability, and you have government entities that are going to be investigating the use of those funds. So that's something that private companies need to be aware of. And government investigations come in all different forms. The government isn't going to necessarily say to you, you are the subject of our investigation, right? They don't have to do that. It can come in different forms. There are investigatory subpoenas. They can ask you for an informal meeting. And so all of these different occurrences can potentially trigger coverage under your policy. And so it's important that when the government approaches you, or even just when you hear, I think a lot of times company attorneys can hear rumblings from the government of whether or not they're going to investigate. And sometimes the government's very clear that you were the subject of an investigation. So it's important to engage coverage counsel or, to check your policies to see if you have an argument whether coverage has been triggered. Because as we know, those investigations, and responding to subpoenas can be extremely expensive for companies. And so sometimes that defense coverage is really what a company is looking for, particularly in these tough economic times. You don't want to be spending out of pocket for an expensive attorney to protect yourself when that might be covered by your D&O policy. Furthermore, the longer you wait to potentially give notice, if you do have a claim, you're running the risk of your insurance carrier saying they're not consenting to your defense counsel. So you want to make sure that you're in communication with your insurer and that you're keeping them aware of what you're doing if you are incurring fees. Even if it might not rise to a claim under the insurer's, perspective at that point, you want to keep them aware of what you're doing so they can't later argue to you, well, you didn't tell us you were incurring defense fees. You didn't tell us that you had other fees, perhaps expert fees, data retention if you're producing a lot of documents. So Government investigations are a serious concern, and if you are subject to one, or if you get a subpoena, you should definitely look to your policy for coverage.
All right. So, Theresa, do you want to make any comment about that as well?
Well, one of the other, things that we think is going to be prevalent here, or liabilities that we expect we'll see, is return to work claims. Sort of taking a left turn here, talking generally about employment claims. The fear, I think, is that there's a chance that there's going to be discrimination or wrongful termination type claims that could arise following the return to work of the vast majority of our workforce. So, for example, to think of what could happen here. There's a company that's furloughed, 90% of its workforce. Now it looks at bringing that workforce back, and the directors and officers say, well, we'd like a young, healthy workforce, so let's tell everybody over the age of 50 that they're terminated, and we'll just bring back the young folks. Obviously, that's probably not legal, but it could trigger your employer liability coverage, EPLI coverage, because that type of coverage protects companies and the directors and officers from things like wage and hour claims, discrimination claims, OSHA violations, all of those types of claims. So there's a lot of different things that we could be seeing that could affect both public and private companies in the future. Grace, did you want to add some statistics? I know you have done some research on that.
Yeah, sure. Just really interesting, based on the current climate that we're in. There have been a ramp up in investigations by the SEC. The SEC received a surge of tips and complaints since mid-March, specifically over 4,000 new tips, which is a 35% increase from the same period last year.
So, Alex, did you want to comment here?
Sure. I also just want to point out, so typically we think of SEC investigations, we're thinking that those are going to be subject to, or that public companies will be subject to those investigations. But I do just want to note that private companies are still subject to Section 10B of the Securities Exchange Act, which addresses manipulative and deceptive practices in the sale or purchase of a security, whether that be private or public. So it's important that private companies are also still seeing this exposure.
Yeah, I think it's just worth highlighting, as you guys are pointing out, that I think a lot of people have D&O policies and they're not aware that a government subpoena, when it arrives, might be something they need to give notice to their D&O carrier for, because there may be coverage for what can often be very expensive attorney's fees in gathering the information that the government is looking for, and those investigations can last a long time. I know that several of you on this panel have had experience with exactly getting coverage for that, and sometimes our client was very pleasantly surprised that we were able to find coverage for their attorney's fees that they spent on the, sometimes either as a witness or otherwise part of a criminal investigation.
That's absolutely true, Tracy. That speaks to the point I made earlier about D&O coverage being broader than, your typical liability policy, because it applies when there's even a subpoena could be enough to trigger the coverage. And like you said, the costs associated with that can be astronomical, and there's never a suit filed. So in a lot of, I think, risk managers' minds, unless there's a suit, there's really no insurance that can come into play. That's not true when it comes to these D&O liabilities. So one of the main things we want to say today is you should really be thinking about this line of coverage, because it has vast potential to protect you from a whole range of liabilities that could arise because of COVID.
So Grace, can you tell us maybe a little bit more on this regard about the types of things we're seeing filed against companies that implicate D&O coverage, and maybe any special conditions for public companies?
Yeah, to switch gears a little bit from private companies to public companies, one of the largest exposures that publicly traded companies are facing right now are securities class actions. We're seeing a lot of event-driven litigation following COVID-19 outbreak. And the common theme that's underlying these securities class action suits is that they're based off of statements that the company's made about certain action or inaction that's been taken, or certain representation or misrepresentation, any improper disclosures to investors that's influenced their decisions. And it is very common to see event-driven securities class action suits follow an event that's coupled with a drop in company stock price. One really good example of that actually is what's resulted from what people have termed Zoom bombing. And that actually led to, and Zoom bombing, just to explain quickly for those who don't know, is when a Zoom meeting is going on and it's meant to be private within an organization and some outsider drops in. So that led to a lot of companies either prohibiting the use of Zoom, and following that, Zoom is now facing 2 securities class action suits on the basis that Zoom sort of overstated the degree to which the software was encrypted. And Alex and Theresa can talk a little bit more about some of the other securities class action suits that have popped up.
Alex, do you want to jump there?
Sure. Sorry, Tracy, to cut you off there. Absolutely. So not surprisingly, Norwegian Cruise Lines has been hit with one of these securities class actions back in mid-March. Their security holders filed suit against Norwegian Cruise Lines, its president and CEO, as well as its CFO. So not only the company, but also directors and officers were subject to this lawsuit. And specifically, the claimants are alleging that there was materially false and misleading statements in Norwegian's filings with the SEC. They said that the cruise line employed sales tactics of providing customers with blatantly false statements about COVID-19 with the intent to get them to purchase cruises. So obviously, as Grace said, this was tied to a drop in the stock price of Norwegian stock. And so these claimants are alleging they've been damaged by these, what they say, materially false statements by the cruise line.
So, Theresa, maybe what else have we seen out there these days that's interesting in regard to COVID-19 on D&O coverage?
Yeah, so there's another lawsuit that we're aware of that was filed against a company called SC Works, which is a publicly traded entity. And it's being claimed that they violated some federal securities laws because they made false and misleading statements about the nature of the supplier that they had for COVID-19 tests. So it's interesting, you know, whereas some of these other suits are sort of tangential to what's going on or resulting from COVID-19, this really is right there talking about the testing that's available and the supply and demand issues. So for companies like that that are involved in the making of the tests, the distribution of the tests, they have to be very careful that they're not overstating the volume that they expect to receive and to distribute, because that can expose them to liability, which is the case here with this SC Works company. And, you know, as a result of their alleged false and misleading statements, it's being claimed that, you know, they lost a lot of money, that the shareholders lost a lot of money. So it's going to be all across the board, I think, which is interesting. You know, we see these companies that are making tests down to cruise lines and Zoom itself. So I think it's interesting.
And not related to COVID-19, of course, because these cases are new, but we've seen a number of these types of cases in the past. And of course, the audience should understand that we're now discussing what the liabilities are that tie in with D&O coverage. We're not the lawyers who defend that. In fact, we expect the insurance company is going to pay for those lawyers. And often our fight is to get the insurance company to make sure that the defense fees, which can be very expensive for these type of cases, is paid for by the insurer. So just, you know, jumping back to you for a second, Theresa, the type of cases that you guys were just describing, where do these fit under the D&O policy provisions? Is there coverage for the defense and potential indemnity of these types of claims?
Right. Yeah, exactly. The D&O policies should provide coverage for this type of lawsuit. We would have to carefully look at the policy provisions to make sure there's no exclusions that could apply. But generally speaking, this is the new wave that's triggering D&O coverage, these securities or shareholder suits, because the D&O coverage is so broad and provides coverage for any wrongful acts committed by the company. Did anybody else want to add to that?
Go ahead, guys.
Yeah, so particularly, if the company is subject to the suit, you're going to think about side C coverage, and the public versus private side C coverage is different. So if you are a public company, typically your side C coverage is limited to these types of securities actions. And again, like Theresa said, you're going to want to look at the exclusions to make sure nothing's going to impact your defense or potential indemnity. And a lot of times with these securities class actions, it's just a matter of, getting past the pleading stage, and, a lot of them aren't necessarily successful, but the defense is extremely expensive, particularly if you're looking to get experts. With regard to defense for the directors and officers that are implicated, most likely that will be side B coverage, assuming the company is providing that indemnification. But if for some reason they're not, or if there's a liquidity issue, side A coverage can also be impacted.
So Grace, were you going to comment as well on these issues about what coverage is out there for these?
Yeah, sure. I can just add that typically, I didn't mention it in the Zoom suit, but a lot of these suits are brought against CFOs, CEOs, and the company. So you are going to be looking at probably, at least two different sides of coverages available under the policy.
So throwing back to you, Alex, is there other things that you would want company management to be aware of regarding their duties and responsibilities and potential coverage under these D&O policies during this COVID-19 crisis?
Yes, so directors and officers and companies also have, a broad duty of oversight and might be subject to oversight claims. So unfortunately, this is a tough time for companies. They're challenged with liquidity issues and reduced revenue, perhaps based on the shutdown. They're changing the way they work, where they work, and bringing their employees back on site. So, they have an obligation to oversee, the corporation's operational viability, legal compliance with, the laws that they're subject to in their industry, as well as financial performance. So if a director or officer fails, to monitor and oversee, these types of, issues, then they could be subject to a breach of the duty of loyalty. And so, basically directors and officers of a company must make a good faith effort, i.e. they have to try to put in place reasonable board level system of reporting and monitoring. And there must be ongoing oversight by the board. So it's something that, you need to continually check in on. And that monitoring and reporting requirement might be different based upon the specific industry that the company is involved in. And that's, like Tracy said, not our expertise, but something that just, private companies and public companies really need to be aware of during these difficult times. In particular, experts are saying, look, that these oversight claims might be extended to cyber liability and other privacy related risks. Every company is facing employees working from home and increased cyber liability. It's really undeniable at this point. So directors and officers cannot, and they should not, turn a blind eye to these increased cyber risks, and should actively monitor and oversee the company efforts in preventing these, potential data breaches and ransomware attacks. And although we're not talking about cyber liability insurance right now, I imagine we will in a future series, and it's important to also look to your cyber liability policy should your company be subject to one of these, ransomware or data breach attacks.
Alex, I'd also just like to jump in and add that what's interesting is that we've seen a lot of misrepresentation suits filed so far related to COVID-19, but what we haven't seen yet are exactly what you're describing, are these mismanagement type suits. And what's interesting about these is the burden of pleading and proving these claims is really hard. There's a very high burden to show that the executives breached their duty of of loyalty or oversight. So it'll be really interesting to see how these suits unfold when they do come, because they probably will.
Well, Grace, why don't we stay with you on this issue? And what other types of either unanticipated or more unique exposures might we expect during the COVID-19 crisis?
Sure, Tracy, I can speak about that a little bit. When you think about the current climate that we're in related to COVID-19, we're seeing a lot of personal data and health information being used. And you might not immediately think of D&O coverage for something like this, but when you break it down a little bit further, that might be exactly where companies are forced to turn to cover some of these costs. Even before the pandemic started, biometric data class action suits were an emerging trend. I think between 2018 and 2019 alone, there were 200 of these biometric privacy actions filed. So there's the wave of these suits started because states have begun enacting these Biometric Information Privacy Acts. Illinois was the first to enact one, followed by Washington and Texas. And biometrics, to give a quick overview, are physical or behavioral characteristics of a person, which could include sleep patterns, activity levels, weight, heart rate, things which you could really see being related to an illness. So earlier this year, both Facebook and Google were hit with these kind of suits, alleging that they were improperly storing and collecting facial templates without authorization. And consider now that companies like Fitbit and other wearable devices are actually collecting this data from users to help research COVID-19 trends and potentially see whether these trends of the biometrics that they're collecting could help predict whether or not people have the virus. If these companies aren't complying with the BIPA statutes, which regulate the collection and storage of this data, coverage we would likely see suits filed by individual claimants and possibly in the form of class actions. The stakes are very high, and coverage for these would be very important because, for instance, Facebook paid $550 million earlier this year to settle the suit against it.
I want to jump in and add something too to that. You know, we've been talking a lot about the high cost of defending these actions. And one thing I don't think we've mentioned yet is that a lot of these policies have what's called eroding limits. The policies have a overall limit, say it's, you know, $1 million. And any dollar spent on defending the claim actually reduces that limit of insurance. So that's often comes as a surprise to some companies who are used to defense being outside of limits. That's the typical way a general liability policy pays. So in these cases where the stakes are so high and the defense costs are usually very, very high, it's critical to have someone, you know, like SDV shepherding the coverage action to make sure they are accessing all the different parts of the D&O policy and accurately tracking the exhaustion of the limits. We've gotten into some very interesting disputes over the years with actually, you know, plaintiffs who are claiming the very act of defending is bad faith because you're reducing the amount of money available to us to settle, which is kind of crazy if you think about it. But there's a whole bunch of issues that can come up while you're actively engaged in these lawsuits.
So Alex, did you want to jump in here and talk maybe a little bit more about things like the technological developments and how they might affect liabilities that might be covered under D&O?
Sure. As you know, Grace mentioned, the wearable technology and the privacy concerns surrounding that, we can also see similar parallels to contract tracing. You know, states are really struggling and trying to ramp up contract tracing. And, you know, I think arguably some of the best ways to do that is technology, whether that's an app on your phone, with the onset of GPS monitoring, there's technology that can track not only where you've been, but who you've been near. And so it'll be interesting to see if any suits arise out of those types of applications for COVID-19 and the contact tracing that's so important in tracking the disease.
So throwing it back to you, Theresa, with that idea in mind, do you see any difficulties or obstacles to coverage under the D&O policy regarding these type of privacy suits?
Yeah, there are some concerns about whether or not privacy suits might be covered. Again, our common motto as coverage lawyers is, the language of the policy really matters, and we have to review it carefully to make sure, because one word can make a huge difference, essentially. But we know that, wrongful acts, that's broadly what's covered by a D&O policy, and how the policy defines that. It's usually pretty broad. But once you get down into the exclusions, there might be some exclusions for invasion of privacy. We've seen definitions of bodily injury in the exclusions being extended to privacy type suits. So there are a couple potential pitfalls there, but I think, as both Grace and Alex mentioned, because these are so high risk, our recommendation is, get your carrier on notice as early as possible if you know that you're going to be subject to one of these types of claims, because there might be a possibility to access that coverage and you don't want to lose that opportunity.
So Theresa, if you don't mind, let's stay with you, because if you let us off at the beginning here, kind of giving the overview of insurance coverage, and now we've talked about the different liabilities that might come up with COVID-19. Can you kind of walk us through maybe the applicable exclusions or any things that might be involved in satisfying the insurance agreement with these type of claims in mind?
Yes, absolutely. Well, like I said, the insurance agreement is usually pretty broad. It covers loss resulting from claims against the insured during the policy period for wrongful acts. And those are generally defined terms, and they're usually pretty broad. Where the troubles come in, or where the pitfalls are, is really the exclusions. So one important exclusion we've been evaluating is obviously the bodily injury exclusion. And how that is phrased is critically important here. It makes sense that a director's and officer's policy wouldn't cover bodily injury because you should be looking to other policies for that. But if the exclusion is very broadly worded, we're concerned that carriers might take the position that, these liabilities arose out of bodily injury. They arose out of the disease, COVID-19. And that therefore, a shareholder derivative action or a privacy lawsuit or any of the things we've talked about, they might claim are not covered. So we have some concerns about that, and we anticipate that might be a litigated issue. Tracy, were you going to add something?
No, I was just going to say, if you were done with that, I kind of want to close out the program with that, talking about not just claims, but the issues that we see on people's renewals. I think that maybe some people in the audience know that we often work with people's brokers in looking at the policies upon renewal to make sure that either changes in the law or circumstances such as COVID-19 might impact what type of coverage you should be looking for. And Alex, I'd love it if you could just kind of jump in here and talk about tips for companies with their renewals.
Absolutely. So now is the time, regardless of whether your policy renews in a month or 5 months from now, policyholders need to be proactive in their renewals this year, not reactive. Think about budgetary concerns now. It is across the board that D&O policies premiums are increasing. And so companies should prepare for that. And in addition, companies should think about speaking with their broker to determine if any of their insurer is adding a virus exclusion to the policy. We are seeing some carriers adding these types of exclusions. Some carriers are not, though, adding this to the D&O coverage. So know what your specific carrier now might be adding, and at that point, ask for a sample. Ask your broker to see if you can see the exclusion that your insurer might be adding to your policy upon renewal, and speak to Coverage Counsel about that. Understand how that exclusion might impact your coverage moving forward. In addition, if you're thinking about changing insurers because of perhaps one of these COVID-19 related virus exclusions, you need to discuss with your broker and potentially counsel regarding how your new policy may interact with your old policy, and ensure that there's no gaps in coverage. This is particularly important when you're dealing with claims made coverage such as D&O coverage. You want to make sure that any claim that comes in the future is not going to be excluded by your new renewed policy and will either track back to your old policy or will be captured under your new policy.
So Grace, you're on mute. So if you could jump in, take off mute, and maybe give us your.
Sorry, it's bound to happen, I guess. I just wanted to jump in and add a little bit to what Alex is saying, that in addition to looking for virus exclusions, we are probably going to see a surge of added pollution exclusions on D&O policies. And those might at first glance appear to not relate to something like the COVID-19 virus, but policyholders should really carefully review the wording and definitions that are in the pollution exclusion, especially with regard to what constitutes a contaminant or pollutant. So it's a very keen eye is needed when looking at these renewals.
So I want to kind of emphasize something that I've been emphasizing since I started giving programs many, many years ago, that I swore to myself I wouldn't do any program without emphasizing notice. I was just so tired of having a good claim have the entire battle be about the timeliness of notice. And Theresa, I'm going to throw it back to you and point out, as Grace used the line that I think it was Grace that said, you should give notice early in office. I've always referred to it as the way the voting takes place in Chicago, early and often. Take us a little further on the issues of the notice, and even the app, because we tied together earlier, you did earlier, the application issue and the notice. Could you kind of walk us through that before we close out?
Yes. What I think is important here in the renewal process is to not give short shrift to the possibility of COVID claims. We really can't stress enough how important the application process is and an early notice here. Because if you don't give notice under the policy that's in place when a claim arises, you could be forfeiting your coverage altogether. And like Tracy said, there's nothing more frustrating to us than having a good claim be destroyed by notice issues. One thing we wanted to point out too is that Insurer Counsel, that we've heard Insurer Counsel talking about all these issues, the same issues we were talking about from the policyholder perspective. And one of the things they're saying is that we're being ridiculous by telling our clients to put their carriers on notice early. Well, our feeling is that if you come out and tell us we don't need to put those carriers on notice because they're not going to use that against us in the future, then that's fine. But they haven't done that yet. They've stayed silent about this. So we need to be conservative and careful and make sure that those notices are in, because it would not be fair to face denials because of late notice on these COVID claims. This is a hugely uncertain area of the law that's going to probably develop over the next, I would say, 5 to 10 years even. And we want to make sure that we're really talking about the substantive issues, not late notice.
Let me jump in and say, Counsel did a great job in doing an overview of D&O to start with, how what the COVID crisis, what type of liabilities can be expected, and what type of losses our clients might see, and applying those coverage principles to those losses. I think for more information about COVID-19, relevant to both D&O and everything that's going on with this 10-part series, everybody should take a look at what's at www.sdvlaw.com/coronavirus and other resources that are at that site. But I do thank everybody for doing this program. I really enjoyed moderating, and you guys brought a lot of good information to the table. And you can see on the screen now contact information for any of us if you want to reach out and talk to us. We are strong believers in a team approach. We work with our risk management, in-house counsel, and their brokers very strongly. And anybody who has questions, feel free to pick up the phone and talk to us about it. Thank you very much.